fourth case is we once again have Mr. Kohler with Progressive American, and we have a new attorney, Mr. Higgs, for Shazam Auto Glass. Mr. Kohler, are you still via phone, sir?
Yes, Your Honor.
Okay, we hear you loud and clear. Are you ready?
Yes, Your Honor.
Would you like 5 minutes?
Yes, Your Honor.
Okay.
Okay, so this case is similar to the last one we just argued, though there are some differences. First off, this being a window replacement rather than a repair, and there's not a double AOB in this case. It is a single assignment of benefits from the insured to the glass shop. So those are the two factual differences, but the trial court decided to apply the same order that it applied in the other set of cases, which sua sponte rewrote the appraisal clause, creating a good faith negotiation requirement that was not raised by anybody, and also striking the mandatory component of appraisal, which also was not raised, at least as the trial court phrased it, by any of the parties in this case. We maintain our position that this is essentially a bailout for the glass shop, knowing full well that there's an appraisal clause in deciding to do business with these insureds anyway. It's essentially trying to get a bailout of a bad business model where it doesn't consider the cost of doing business, which is appraisal costs. And again, Progressive American Insurance Company versus SHL Enterprises 264 SO3 1013 was the case where this court decided that appraisal costs are costs of doing business. So what the court did here is it didn't actually allow any hearing on the issue of whether that order from the other set of three cases would apply here. Instead, it just sua sponte applied it. There had been a hearing in this case at one point on the issue of whether there would be an evidentiary hearing on the prohibitive cost doctrine and any other issues that Progressive wanted to raise, and that evidentiary hearing was granted by the trial court. The issue is it never happened. The trial court didn't follow through with that. Progressive filed a motion for a stay pending some other appeals that have since been resolved and canceled the hearing after it was scheduled. And at that point, a few days later, the trial court issued this order, which sua sponte applied the order from the other four cases, Wolf, Gill, and Ernessa Johnson, to this set of five cases, finding that prohibitive cost doctrine does not apply in the appraisal context. So it reapplied that finding, but also striking the mandatory component of appraisal to resolve the conflict between appraisal and public policy in 627-428. Now, I've argued this point in the last several cases as far as the issue of striking of the mandatory component and the good faith and the addition of a good faith negotiation requirement, which essentially rewrote the contract to insert that. The additional issue in this set of cases is due process. Progressive contends that the trial court needed to give it a hearing on whether this other set of orders would apply to this set of cases. The trial court can't just go and take the set of facts from the Gill, Wolf, and Ernessa Johnson cases and then import them into these. That's not proper, and it's not how stare decisis, or to the extent he's considering the stare decisis and applying his own order, works. Under Rubric versus Cone Distribution Incorporated 95 SO3 950, you can't do that. You have to abide by the facts in the case that's before you. But there were no facts in this case because we never had the evidentiary hearing. Plaintiff Shazam filed an affidavit of Sean Martineau. However, that affidavit was never admitted to evidence at any point, and you can't just file an affidavit and have it become record evidence. You have to actually have it admitted under Dominguez versus Bayview Loan Servicing 221 SO3D 699. So we have a case here where there just isn't any record evidence, unlike the other three where they actually had an evidentiary hearing and had a couple witnesses testify. Here, there's no witnesses. You got an affidavit, but it was never admitted into evidence. So we just don't have anything to go on here. There's no competent substantial evidence. I know plaintiff is saying it's overwhelming, but there is none. So Progressive's due process rights were violated here because it is entitled to a hearing on whether that other order applies, since it just was sua sponte applied out of nowhere. and also the ability to cross-examine Sean Martineau, who submitted the affidavit, which is not part of evidence because it was never admitted. So that is the main difference between this case and the other case. Otherwise, the same arguments would apply to issues 2 and 3 concerning the rewriting of the contract to insert a good faith negotiation requirement prior to invoking appraisal and the mandatory component of appraisal. Plaintiff has raised a number of tipsy coachman arguments. The problem with that is, in order to raise a tipsy coachman argument, it has to be based on evidence in the record. We have no evidence here at all. And it also has to be based on a factual finding made by the trial court under Blanos versus Workman. That didn't happen here either, but I'll address them. The first one was access to the court's jury trial and due process. Not raised, not ruled on by the trial court. No evidence, no factual findings. And to the extent that there's any argument that in some of these claims, the named driver was the party that signed the assignment of benefits rather than the named insured, there's a joint individual interest clause in the policy which binds anybody claiming benefits under the policy to the named insured's decisions. So the decision of the named insured to accept the policy binds anybody else making a claim on it. And I can quote it: if there is more than one named insured on this policy, any named insured may cancel or change this policy. The action of one named insured will be binding on all persons provided coverage under this policy. So there's that. Additionally, there's the recent 50 CA case, Mendito Insurance Company, which rejected this argument, finding that appraisal is valid. It doesn't violate access to court's jury trial or due process. The second tipsy coachman argument regards the retained rights clause at the end of the appraisal provision, which states that neither we nor you waive any rights under this policy by agreeing to appraisal. This issue was not raised below. There's no evidence on it. There's no factual findings on it. And furthermore, it doesn't work the way that plaintiff is claiming it works. The insurers are permitted to include retained rights provisions in their policies. That doesn't make it ambiguous. And even if it did, the claim made by plaintiff that somehow that the last resort canon of construction to construe it against the drafter in favor of the insured would apply doesn't work here, because there are other canons that would apply even if this was ambiguous, namely that the retained rights provision is a general clause and the rest of the appraisal provision is a specific clause, and the specific would prevail over the general.
Mr. Kohler, I have a question about the order itself. I understand that arguments, I think by Mr. Higgs, would have occurred sometime after the other cases that we just heard. They were in February, this was in April or something like that, but you're right. The court adopted the order, which for brevity, Herc AAO1 Gill. Do we even have an order denying the motion to compel appraisal in favor of Herc AAO Amanda Stevens?
Well, let's see. Amanda Stevens isn't Herc. So Amanda Stevens would be Shazam Auto Glass.
Okay.
Herc was the other set of cases.
Well, but the only order we have in the Shazam case, is there a Shazam order?
Yes, it is on page 297 of the appendix.
Gotcha.
For the Amanda Stevens case.
All right. Sorry. Go ahead.
It just says, no problem, Your Honor. Glad to clarify. It just says that he was applying the order from the other three cases, Gill, Ernest Stevens, and Wolf, finding that the predictive cost doctrine does not apply in the appraisal context, and striking the mandatory component of the appraisal provision. It's a little unclear whether he also included the good faith negotiation requirement or not. I'm assuming he did, because he adopted the whole order here, and then he denied the motion to compel appraisal and stay discovery.
I'm clear. I'm sorry to take up your time. Go ahead.
No problem, Your Honor. So I was talking about the retained rights provision, Cincinnati Insurance Company versus Canon. Ranch Partners 162, SO3D 140 is the applicable case for that. again, you don't have to reach it because there's no evidence in the record, and you can't do a tipsy coachman argument unless there's evidence in the record. And also, it's factual findings supporting it. The third tipsy coachman argument was appraisal procedures. This is essentially arguing that appraisal needs to have all the procedures of arbitration. It's pretty clear under Allstate Insurance Company versus Suarez that appraisal is not arbitration, does not require the same procedures. And again, that issue was not raised, was not part of the trial court's order.
Well, the policy says that arbitration is binding. If you go through arbitration, Mr. Higgs' clients go through arbitration, how can they file suit?
They can't, Your Honor, and this is appraisal. I don't recall whether we have an arbitration provision as well.
I mean, if they go through appraisal, how can they file suit?
They're not supposed to, Your Honor. They're supposed to go to appraisal before they can.
No, but if they go through
appraisal,
appraisal, and the policy says appraisal is binding,
right?
How
It
are they
is
able to
binding on
file
the
a
issue.
lawsuit?
Right, it's binding on the issue of amount of loss. I guess if there was some other issue remaining after that on coverage, they could potentially file suit, or they could file suit if the insurer refused to pay the appraisal award. But other than that, they would not be able to. Plus, there's a clause in the policy, legal action against us. We may not be sued unless there is full compliance with all the terms of the policy, which there has not been because they did not go through appraisal. So that's all the new things that are different in this case from the prior case that we just argued a few minutes ago. Otherwise, my argument is largely the same, just that these issues were not raised. The invocation, good faith negotiation requirement prior to invocation was not raised, is not applicable. There's all the issues I talked about last time about Rettelhammer and how it doesn't apply because you're just looking at just need the position of both parties on the amount of loss procedure appraisal. You don't need anything else other than that. And the problem with Rettelhammer and the cases relating to it was that one of the parties had not given that position, and it was the party trying to invoke appraisal. So that was the problem there. That is not a problem here because you have both parties' positions. You have the invoice giving Shazam's position, and you have the position of Progressive in the form of the payment that Progressive made to Shazam contemporaneously with invoking appraisal. And making that payment does not constitute breach under the case First People's Trust versus Chen 333 SO3D 208 from the 4th UCA. So unless there are any other questions regarding the differences between this case and the other one around the issues that we've already discussed quite a bit in the prior oral argument, I don't want to just keep beating those issues to death here. So unless the court has any questions, I'll reserve the remainder of my time for rebuttal.
I don't think that we do. You'll have 5 minutes, sir. Mr. Higgs, good morning. Welcome.
Good morning. May I please report? Good morning, Your Honor. I'm Earl Higgs, and I represent Shazam Auto Glass, who I'll refer to as Shazam in this case. We believe that the trial court properly denied the motion to compel appraisal, and the court should therefore affirm. One of the issues that came up several issues came up in the prior oral argument where counsel for Progressive was obviously making the argument there, and I wanted to make sure I addressed some of those. One of the questions or issues that came up in that argument, because they relate specifically to this case, is regarding conditional precedent. And in order for there to be an appraisal, the court has to first determine whether it was a valid written appraisal, there were appraisable issues, and whether there was any waiver of that issue. So appraisal is not even appropriate unless a court first makes the determination whether those issues have been met. And the court in this case determined that, pursuant to the public policy issues that are infused throughout the automobile legislation and automobile policies in the state of Florida, that the court fashioned an equitable remedy that it thought would take into account the public policy procedures that are infused throughout the automobile policies in this case. And so when the court when I believe it was Stargell, and I'm sure Judge Lee as well, was concerned about, well, how can we as courts weigh in on public policy? Shouldn't that be the legislature? Well, the public policy is addressed in 627-428. As this court determined in Merrick, this court determined that the purpose behind 627-428 is to discourage insurance companies from contesting valid claims or not appropriately paying claims pursuant to the policy. The public policy behind 627-428 is to make the insurers whole. And so what the court, we believe, correctly determined was that by allowing the insurance company to steer the insurers to the appraisal process, they circumvent, they evade the whole public policy purposes behind 627-428, which is to make the insured whole. The insurer can't be made whole when they're steered to the appraisal proportion of the policy. Not to mention, one of the questions, I believe it was Judge Atkins, had a question about the disparity between the cost of appraisal versus litigation. And as the court is aware, in this case, in the state of Florida, litigation is free to a prevailing party, especially under 627-428. What the appraisal provision does in this case is it prevents that free litigation to a prevailing party. It actually costs my client, in this case, Shazam, money to engage in the appraisal process, money that my client won't be able to recoup back. My client never has the opportunity to challenge, which is one of the issues that Judge Sleep just brought up. My client never has the ability to challenge whether Progressive is paid the correct amount under the insurance policy. The policy discusses the fact that it needs to be paid based upon the prevailing competitive rate in the prevailing market. How do we challenge that? There's no way for us to challenge that.
Isn't this a business model issue? The part of your business model relies on not having to pay those appraisal fees, but your company made that choice knowing that these appraisal provisions are in there. That's my first question. Then I have a follow-up question for that.
Sure, I don't think it's necessarily simply just a question of a business model. Again, the public policy is specifically set by the legislature in 627-428. The public policy of 627-428 is to make the insured whole. And so the fact that my client engages in business that allows them to bring suit doesn't mean that they give up the right to be made whole in this case. And so I don't believe it's just a matter of a business model.
Well, and the legislature just addressed a lot of these issues, and I'm not real familiar with what the new ones are because it's not come before me. But in that legislation or any legislation, they could have addressed that issue if they saw it as a huge public policy issue, correct? They could have said, well, appraisal, we can't have people requiring assignees or anyone else being responsible for that. That should be the insurance company's responsibility.
Well, I don't think the legislature has addressed this specific issue with regard to appraisals. Most of the case law we deal with arbitration agreements, and we know that there's.
Well, but that makes my point. They had sessions regarding it. It's gone before them. I'm sure your clients could have brought it up to them. The legislature could have acted on the public policy aspect, but they didn't. But even before them, when this was in place, there's no de minimis exception. There's no other requirements regarding this, is there?
Well, no. Again, let me make sure you understand what my point. The business model is not the business model, rather, but let me make sure you understand my point. The public policy is specifically set in 627-428. The public policy behind 627-428 is to make sure that insurance companies make the insured whole. Okay,
and that's on it. So, that's on attorney's fees, though, correct?
Well, that is on attorney's fees, but it's also, again, it's also to make sure that the insurers are made whole with regard to their costs as well. And so, the insured, again, in the state of Florida, the prevailing party has a free of cost litigation once they prevail, and so. Because the state of Florida has determined it's important that the insureds are able to be made whole as a result of the litigation that the insurance company improperly pays a claim or improperly contests a claim, then the public policy behind 627-428 kicks in.
Yeah, I understand your position on that. Let me ask you my second question. As to 6/27/4/28, the recent case that came down, Mendota Insurance, I guess is how you pronounce it. The fifth DCA disagreed with the position you're taking today. So what would you have us do? You want us to come out with a different decision and certify a question up? That's what you're asking us to do now?
Sure, I think, again, well, first of all, that decision is not final yet. It's not, and I was actually attorney of record on that case, so that decision is not final, and the time for filing motions for hearings and things of that nature are still, there's still opportunity to do that. But yes, obviously, we think that the fifth respectfully did not get the decision correct. We would ask this court to take a fresh look based upon the facts in this case. Also, Mendota is distinguished because there are various factors with regard to how that case, came out that are distinguishable from this case. For example, there was no affidavit and things of that nature. So we'd be asking the court to take a second look, a fresh look at it in this case. And so the court is not bound by it and could take a fresh look at it and make its own determination with regard to public policy and arguments with regard to 627/4/28.
Okay, thank you.
So again, in this case, the trial court essentially fashioned a public policy remedy that it thought would take into account the issues that were raised in this case. So there was no valid, we believe there's no valid agreement because it violated the public policy behind 627/4/28. This court in Flyer Printing and in Hope has previously determined that a arbitration, again, that was an arbitration, but this court is, and we would present that it's similar and analogous with the arbitration agreement, such that when an agreement such as that, an arbitration agreement restricts the right to recovery of statutory fees, this court has determined that that arbitration agreement is enforceable. Again, that's what we submit has happened in this case. The appraisal provision and that progressive policy restricts the right to statutory right to recover returns fees, and this court has already made that determination again in Hope and Flyer Printing. With regard to the access to court, counsel mentioned that the argument wasn't raised below, but that argument was specifically raised in Shazam's response in opposition to the motion to compel. Shazam raised the fact that there was no record evidence that there was any knowing or voluntary waiver of the access to courts or right to jury trial. And this court has even pointed out the fact that the ambiguity that is in the appraisal provision. So for example, the appraisal provision binds the parties to the amount determined by the loss, but at the same time, in the case that neither party waives their right under the provision of the appraisal provision, there's absolutely no record evidence that my client or even insurer for that matter waived any right to access the jury trial, right to access the court in this case. One of the issues that counsel brought up in his argument was that the retained rights, and there's cases that says the appraisal provision can allow retained rights, but all of the cases that counsel cites to are cases that deal with retained rights one way. That is, the insurance company retains the rights one way. That's significantly different from what we have in our appraisal policy provision in this case. In this case, both parties retain the rights to waive. Both parties retain their rights. They're not waiving any rights. And so because both parties retain those rights, the only right that it makes sense, rather it's logical, that it allows the insured, in this case, my client who stepped in the shoes of the insured, to challenge the amount paid under the appraisal provision, challenge to make sure that the progressive paid the appropriate amount under the policy. And so we believe because there was no valid agreement, the court was correct in fashioning this this mandatory provision, striking this mandatory provision of the policy. One of the other significant issues also is the fact that one of the factors the court must look at before it can even determine whether there's an appraisal, whether you can go to appraisal, is whether there was a appraisable issue that existed. We contend there was no appraisable issue that existed because there was never a disagreement. In order to have a disagreement, you have to have a meaningful exchange of information between the parties. Unilateral payments, such as the one that Progressive made in this case, never signify a disagreement in the policy. As we cited to in our brief, we mentioned Couch, and Couch talks about the fact that, and I quote, a disagreement is triggered between parties in an appraisal context. Well, Couch was talking about arbitration, but we know that they're similar with regard to that aspect. Difference of agreements, a disagreement is triggered when there's an existence of a real difference of fact arising out of an honest effort to agree between the insured and the insurer is necessary to render operative a provision in a policy for arbitration of differences. Furthermore, there must be an actual and honest effort to reach an agreement between the parties, as it is only then that the clause for arbitration becomes operative, the remedies being successive. So our position is there was never any real honest effort to try and reach an agreement in this case. Progressive just simply unilaterally made a payment and requested appraisal without any real effort to make a determination whether there's a disagreement. You don't have an appraisable issue here. And we submit that because there was no appraisable issue, in addition to the fact that we didn't have a valid written agreement, then the court's order was appropriate.
Well, wouldn't that be reading into the appraisal provision? Wouldn't that run into the same problems addressed in the argument you just listened to that my colleagues have raised, which is that if we were to agree with you that there must be some showing of a good faith effort to reach agreement, that this court would be rewriting statute instead of allowing the legislature to do that and implementing, or I guess, excuse me, not the legislature, sorry, the parties to the agreement to write a different statute or allow the legislature to impose regulation on such appraisal provisions.
Absolutely not. And then we addressed this in our brief, Your Honor. Again, the law we submit, and I just read the law, Couch, Rome, all those line of cases, the red hammer case that counsel talks about, all those cases are all on force, and that is the law of the state of Florida. There needs to be a disagreement. There hasn't been a meaningful exchange of information in order for the parties to even determine whether there's a disagreement or not. In this particular case, the insurance company, Progressive, just sent a check, and they provided a receipt, but didn't explain exactly what they were paying for. My client couldn't even determine, and he mentions in that he couldn't even determine whether are they paying for some things or not paying for other things. And so,
what information needs to be exchanged other than the information that we think the amount should be a amount lower than requested, and this is the amount we think it should be, in order to achieve what triggers the right to demand appraisal, which is that the parties cannot agree?
Well, again, I believe Couch addresses this, Rome cases addresses it. They also, there's got to be a meaningful exchange of information in order for the parties to make a determination whether there's a disagreement or not. So you got to tell me, if you're paying for something, you got to provide me with an explanation of benefits to tell me what you're paying for. So I can say, oh, you know what? That's not a disagreement, but this portion, this aspect of it is. And so we believe the law specifically requires it. So it doesn't require this court to rewrite the policy because the law already requires it. And in fact, Appellee's own policy provision requires it as well, because in the policy, the language reads, if we cannot agree with you on amount of loss, then we or you may demand an appraisal of amount of loss. We believe that policy, in conjunction with the law, with Couch, Rome cases, and all the other line of cases, specifically requires the court, the parties to engage in a meaningful exchange of information. And so the argument that the court, in this case, sua sponte, raised these issues about negotiation, We believe that's absolutely incorrect. The policy and the law requires them to do so. And all the trial judge did in this case was apply Gill exactly the way the law and the policy requires it to do so.
Yeah, but can't we presume that your client who is in the business of repairing windshields knows what they're doing and they have the sophistication to be able to repair and or replace, and they know how much it costs, and that their bill that is submitted to Progressive is correct? I'd take that as a yes. So, and next,
Well, no,
Progressive then gets the bill. They disagree with the bill and issue a check at a lower amount and say there's a disagreement. What else needs to be done?
But a disagreement as to what? I mean, I don't.
You
again,
charge too much is basically what they're saying, I guess.
But we can't make that assumption. We can't guess. They have to specifically tell us what the disagreement is. And we submit, the law requires them to specifically tell us what that disagreement is. So what those issues are, so we can determine whether there is a disagreement or not. We can't simply just assume or guess. They've got to provide us with an information. And when they don't, we believe this policy provision violates the law and their own provision, because they don't provide the information necessary for us to determine whether there is a disagreement.
but
So
your
for the trial court
client-
to even determine
Your
whether
client could
we
have
should go to-
requested mediation.
My client doesn't have to request a mediation. There's
You
nothing in
can.
the policy that requires it request a mediation.
But how is it reasonable to say that you don't even know what they based it on, but yet you file suit? If you file suit, you're basically filing sworn pleadings that they're wrong. But yet
Yeah.
you're telling me you don't know what they're basing it on, but then you're filing suit saying they're absolutely wrong. Doesn't make sense.
No, that's not what I'm saying. We filed suit because they didn't pay the amount that they were supposed to pay under the.
Okay, so
under
you're
the
certain
policy.
about the amount. So that there
What's that?
appears to be a bona fide agreement about the amount of loss.
No, that's the point of the lawsuit. We disagree as to what they paid, and the only way for us to challenge whether they paid pursuant to their policy. Their policy says they have to pay based upon the prevailing competitive rate. We believe they haven't paid that amount, but we can't just say it. We have to prove it. The way to prove it.
So it sounds like you disagree about the amount of loss according to your lawsuit, but you believe there's no disagreement about the amount of loss for the purposes of appraisal.
I didn't hear your question.
You asked earlier what were the, we're confused about what they don't agree about, and it's the appraisal says amount of loss. That's what it's about. And you, from what you just said, it sounds like you, according to your lawsuit, disagree on the amount of loss.
Yeah, well,
you're saying there is no disagreement on the amount of loss.
Well, let me make sure our position is clear. We see this, first of all, we don't see this, we don't concede, and we don't see this as an amount of loss case. We see it as a policy interpretation case, whether Progressive paid the appropriate amount of the prevailing competitive market rate. That's what we see this case. So this is a policy.
What's the amount of loss? What does that mean?
It was under the policy you're asking me, or what my opinion of what the amount of loss is?
What does amount of loss mean?
Well, it can mean several. The amount of loss can.
What does it mean?
Deal with
aren't we here based on the appraisal provision?
What's that?
Aren't we here based on the appraisal provision?
Yeah, the amount of loss is based upon
So what does it mean in the
Based on
context
the
of the
price.
appraisal provision?
the price, or the amount that the parties of the.
So explain to me the distinction between that and a disagreement over what the policy requires regarding the let me go scroll up here and see what it says.
While you're doing that, you're at 20 minutes, Mr. Higgs, but I'll give you 2 more minutes.
Okay.
Answer the question.
I don't want to misquote the prevailing competitive labor rates.
Correct. That's what the policy says. The policy says that Progressive has to pay based upon the competitive prevailing rate.
Doesn't a disagreement about that constitute a disagreement about the amount of loss?
Well, but before you can get to that, the court has to first determine whether you even had a valid contract. That's what Romney talks about. That's what the case law talks about. And we submit, and the trial court found that there wasn't a valid contract because because it violated public policy behind 627-428. So before you even get to that, the court's got to first address the threshold requirements before you even get to appraisal. So for the reasons that we've stated in our brief and we've argued here today, we respectfully request the court to affirm the decision below.
All right, thank you very much. Mr. Kohler?
Yes, Your Honor. All right, so, yes, Your Honor. Okay, on the issue of what the amount of loss is, again, we have to distinguish between the amount of loss and the limits of liability. Limits of liability are just the maximum amount that Progressive would have to pay, but that's only if you invoke them and you actually decide to limit the amount of loss based on limits of liability. They're two separate things. They're not one and the same. The amount of loss is something that Progressive can estimate. And under the settlement of claims provision under 237 of the appendix in its policy, we may use estimating, appraisal, or injury evaluation systems to assist us in adjusting claims under the policy and to assist us in determining the amount of damages, expenses, or loss payable under this policy. And it says, there's a little bit of a gap here, but it says amount, then you have of damages, expenses, or, and then you have loss. So you have amount of loss right there in the policy. Secondly, Progressive's policy in the appraisal clause is different from the policy in Romay, Rettelhammer, and the other case that was filed, certain underwriters. It says if we cannot agree with you on the amount of loss. In Romay, Rettelhammer, it said if you and we cannot agree on the amount of loss. So you have different policy language here. It's much more unilateral in its wording than the policies in Romay and Rettelhammer. But in any event, the issue with Rettelhammer, Romay was that there was a party invoking appraisal was not giving their position on the amount of loss. And the amount of loss is simply what the insurer and the insured believe this claim is worth. It isn't about the limits of liability. That would come later if the insurer wanted to invoke that to limit and reduce the amount of loss to whatever the limits would be. Progressive doesn't do that. Progressive just pays the amount of loss determined in appraisal. So I think that's a critical distinction we have to keep in mind here. Secondly, I think they did raise the issue of access to court's jury trial and due process in their response to the motion to dismiss and compel appraisal. However, they did not raise the issue of invocation. The closest they come, I think, well, they didn't really come very close. It would have been, they argued that Progressive had waived appraisal by making the payment unilaterally, contemporaneously with appraisal. That's on page 215 of the record, where they argued in this case the defendant did not deny coverage. Instead, the defendant made a unilateral decision to pay a lower amount without first participating in the appraisal process, which it purports to invoke after the fact. So I don't think the issue has been raised in their, neither at the hearing nor in their response to Progressive's motion to dismiss, stay, and compel appraisal. So the issue here is just simply what is the amount of loss. It's not what the limits of liability say. It's not what the prevailing competitive price is. The appraisers can do whatever they want, really, as far as determining what the amount of loss is. They're not bound by the limits of liability clause at all. So all this issue about we don't know what they paid under as though it's going to some sort of line item is irrelevant. It's the only issue here is the amount of loss as a total. It's not whether there's line items under that or not. It's just what the full amount of the value of the claim is, the amount to, in this case, it's the amount necessary to repair the vehicle by replacing the windshield. In the other case, it would have been the amount necessary to repair the vehicle by repairing the windshield. That's all we're talking about here. So in conclusion, this is just a situation where Shazam is attempting to get a bailout from the courts on a bad business model where they did not consider the cost of appraisal, which this court has ruled is the cost of doing business.
By making the distinction you made, I'm anticipating Mr. Higgs arguing that that might have been his point all along, which is that by merely paying an amount lower than what was requested, that doesn't communicate the requisite information to put the insured on notice to understand that there's a dispute about the amount of loss, as opposed to, for instance, a dispute amount of a liability limitation that caused the insurance company to.
I think they're on notice. I think they're on notice in the letter where they argue that when Progressive says reasonable and necessary, it's not the same as the limits of liability costs. So I think
Okay.
you're on notice about that. And you're invoking appraisal, so obviously you mean the amount of loss, or you wouldn't have it quoted there. I mean, we quote the entire appraisal provision and say we're invoking it. So I don't think there's any confusion at all on that point. I notice my time is up, and Progressive would ask that the court reverse the order on appeal. Thank you.
Thank you very much, both of you. Well argued. If you could leave the Zoom hearing and have